important subject in interpretation, both at the level of international law and domestic law. Obviously, the treatment of context is not as much systematic on the municipal plane as it is on the international plane. The reason being, as I told you in the very beginning, the treatment of this subject on the international plane has always been systematic because it was a matter before the institutionalized body at the international level of the United Nations making, that is the International Law Commission. Whereas on the municipal plane, you have a different approaches, and there are only very few enacted legislation in this field, and all those legislations they pertain to mostly one legal system, that is common law of the English type and its various other manifestations such as American system, Australian, Indian, Japanese, Hong Kong. Of course, I'm speaking of Hong Kong before it was returned to China. Well, Hong Kong does have a law, enacted law or interpretation of the British making. I'm not sure obviously how far the Chinese are going to treat it, because not only the reason what is happening currently, but also earlier. Because in the Chinese legal system, courts are not always the sole authority to give interpretation. So that is totally at variance with the treatment of the subject by common law and American systems. Let us come back to this. But as far as international law is concerned, you have much more elaborate system. As far as Hindu law is concerned of Mimamsa origin, that is also very much elaborate and significant in the treatment of context in interpretation. There are also secondary writings, some of which I have indicated to you in the readings, and you will find it most importantly the readings, the writings by Lon L. Fuller, and at a less theoretical level but more practical level by the writing, the classic article written by Judge Frank Porter in the Columbia Law Review of 1948 or 49, whatever. You have the reference to that. Let us start with it. Of the earliest origin, this is by now almost universally accepted that Hindu legal system represents the oldest system of treatment of issues of interpretation, although not initially and from the very inception in the context of legal text. So the Hindu approach to legal interpretation developed out of the treatment of the subject in the religious context. I would say, if you visit some of the temples of South India, you would find something very interesting. I don't know whether you have visited Meenakshi temple or other temples, Brihadiswar temple at Tanjore. If you visit these temples, you will be surprised to know that these are not merely temples. And I will see, for instance, I have visited these two temples and I found this thing very interesting. Temples in the North India and temples in the South India. In the North, temples are merely for religious activities. But temples in the South India, they represent a huge complex. There you would find even shops, and you can find almost all things. The reason is, I asked some people, they said, and this is also corroborated by, you see, authors of the religious text, that they consider temples, and it is true, as part of the human activity. So the whole human activity is represented there, so you can see the temple in a context. Temple is not seen in isolation. It is part of the whole of people's life. Similarly, they usually develop this because in order to understand a written text, whether it is of religious text, you need to know certain rules, certain principles of understanding. Now, one of these principles is called in Hindi prakaran. So in English we have to write it, and that is why we write it in italics. Any word which is foreign to the language that we use is written in italics. That is the normal understanding of writing. But in Hindi it is written as prakaran. Prakaran. So I don't know whether it can be written better than Prakaran. So the pronunciation of a it is not always you see exact what it is in Hindi. So sometimes ra of Hindi is not a full ra. It is ra which is half. So similarly, the first A is actually not full ra of the. But people, I'm sure, I mean, how many of you have learned Hindi, elementary Hindi? You people coming, I know, you people are from North India, so I'm sure you will know Hindi. You, which part of
Kerala.
Kerala? So, have you also studied Hindi?
Yeah, straight until 8th.
Until 8th?
From 2nd to 8th.
So, you follow this word prakaran.
I don't know the meaning.
Okay. Well, your friends will say, I would request you to write it in Hindi after the class, and I will write it to you and show it to you how does it appear in Hindi. So, prakaran means context. It is fair to translate prakaran as context, because there is no better approximation in Hindi, in English, than context. And anybody who would refer to, you say, prakaran, would translate it into English into prakaran as context, on which I have absolutely no doubt. Whatever authors that I have seen and consulted, there is unanimity. I have not found any dissent that prakaran means anything else. Maximum you can say that it may loosely also be referred to as a reference, but I would still say that it is better that you use context. Now, there is a Mimamsa principle, and which states as it is written, of course, all these written in Sanskrit. So there is a limit to which we can be sure as to what we are saying in English. Please appreciate that limitation. And that limitation is very important. Your Malayalam language has originated, I am told, from Sanskrit. So therefore, whatever is written here in English, if you find in any other text a different meaning of this prakaran in English, so please concede, you see, from the very beginning, that this is not found originally in English. So it can't be 100% exact. But yes, the idea certainly is stated as it is. When the words or the sentences of a text fail to give concrete meaning, the meaning of those words or sentences should be resolved with reference to the context of the text. Let me point out the difficulty in this statement. I concede that there are two words which have been used here, which I also have problem in using in English. First word is concrete, adjective. And the second word is resolved. What I am telling you is this. The use of the word concrete and resolved should not be taken very seriously. I used it because I was not able to find a better expression than this. And I myself have several reservations to using this. Firstly, let me illustrate. It is not necessary that you do not find a concrete meaning that you can refer to context. Even if the meaning is not being able to be ascertained, it is also important, or it is also permissible to refer to context. What I am saying is this: the degree of certainty required of a sentence or of a word that would necessitate a reference to context is not necessarily to be a concrete meaning. It may just be meaning. It may just be meaning. You want to be sure. It may also be a case that you doubt the meaning that you give, and you want to be sure, and you want to know. Please tell me in what context he said it. Sometimes a person is reporting you, he said this. And you said, no, that's fine. I know, I have heard what you're saying. But please tell me, where was he speaking? What was the lecture on? And it makes a lot of difference. I have seen people, speaking formally, and during the intervals, during the talks, during cup of tea, and when you insist, when you take interviews, and they will elaborate something, and they will say, please don't quote me. This is unofficial. I am saying it to make you better understand. But I do not want to be misunderstood. So this reply to me of what I have said is basically in response to your question. Of my own, I would never put this explanation. So unless, if you simply quote one particular word and you put it there in the newspaper and then say, that person was saying this, he would immediately respond, you have quoted me out of context. You should have said it. Where did I say it? Did I say it in the lecture hall, or did I say it in the coffee shop, in the canteen? The same professor is speaking in the canteen and is speaking in the lecture hall. There will be a lot of difference. I can tell you some of my own experiences as a student and also as a professor, both when I was a speaker and when I was a student. I tell you at least 3-4 references where I have seen people as high people as the judges of International Court of Justice, and speaking on as important a thing as the judgment on advisory opinion of ICJ. But they did not say it in the lecture hall. They said it was I-10. So I got the point, that he doesn't want to be quoted. He will make me understand. But that is not his position. So he will assist me without taking any responsibility. He doesn't want to take this responsibility because they made it. Similarly, let us get back to the point. What we are saying is this: the necessity of a recourse and the possibility of recourse to context is not necessarily contingent on a higher degree of certainty as to the meaning. It may just be any meaning. It is not improper to refer to a context when you just want to ascertain the meaning of a particular word. It may not be hard, and it is a safe thing to know it, because one particular word may have one meaning, one context, and may have a different meaning in different context. Then there is another principle in Mimamsa rule. It is more difficult than the first principle. And this principle is called Vakya principle. Again, there is a limitation of the language. In English, we say it is a syntactical connection. Do you know what is a syntactical connection? Yes. You all are qualified people and using English language for so many years. You shouldn't be surprised. Tell me what is syntactical. What is the derivative word of syntactical? Let me use a more, precise language. What is the etymology of syntactical? Etymology. Etymology. How did it originate in the language? Well, to your help, syntactical is a derivative of the word called syntax. syntax. But the problem is, syntax is only a rough and maybe incorrect translation of a vakya. To my little knowledge of Hindi, I am sure that vakya is better translated in English as a sentence rather than a syntax. But syntax is basically a genus of the English grammar, of which a sentence is a species. The scope of syntax is wider than a sentence. Yet, a syntax may be limited. So, in other words, syntax is a more comprehensive term. It may be less than a sentence and it may be more than a sentence. So, therefore, in order to assimilate the whole essence of the Vakya principle, it is translated in English as syntactical. But if you go to dictionaries, it is quite possible that you may be more convinced to use sentence than syntax. If you want to read one of the best books written on syntax in English, so you will read Professor C.T. Onions. The name of the book is Syntax, and he is considered to be an authority in the English language. At least two best known authors I know who have always relied on, if there were any problems, any inaccuracies or any controversies about the correct syntax, C.T. Onions. C.T.O.N.I.O.N. Now, what is syntax? Syntax means what Lon L. Fuller, in his article reply to Professor Hart in Harvard Law Review, says integrity of the structure of the language. Sometimes, unless you know, let me tell you, sometimes a word will give you meaning and you understand. Sometimes you need to know the sentence in order to understand the meaning of the word. Sometimes, even if you know the sentence, you are still not sure. Then you have to go beyond the sentence. You may have to read a paragraph. And this is true. This is true. You read these judgments that I give you, sometimes you find that in order to understand what the court is saying in this case, you have to read several paragraphs. And sometimes what the court is saying decisively in one case, it is not to be deciphered from one particular paragraph. It is basically an understanding that you have to cull out after reading more than one paragraph. So that is very important. So therefore, that is what, in fact, in terms of jurisprudence, Professor Fuller has used a very comprehensive term. He said it is the integrity of the structure of that language. The structural integrity. See, in other words, you can't, use a a particular sentence, a particular word as truncated. And there is no limit, you cannot write it in advance, you can't give a key. This is not a magic that one particular person can give like a tablet. Well, the structure of a sentence goes to 3 lines, 3 words, 13 groups. No, you do not know. It may be a word, it may be a sentence, it may be a paragraph, and it may be more than a paragraph. I must quickly corroborate my third illustration because that is very surprising to you. More than a paragraph, I tell you immediately. If you want a case, you can read it. There was a case before the Indian Supreme Court, and the law that had to be interpreted was a Rent Act of the British origin. You'll be surprised to see that this Default Tenancy Act, one section of the act, one section that was at issue, ran into 2.5 pages and more than 6-7 paragraphs. Now you tell me, how do you read one paragraph? 2.5 pages. So the structure, that was it. We're not commenting whether it was good or bad, but that was the case. So these could be, so it's not necessary sometimes that even reading one paragraph you are clear about it. So this Vakya principle emphasizes basically the syntactical connection. And syntactical connection, you see, in English grammar is very important. You should know, you see, in order to understand a syntax, you know how much you have to understand. You need to know parts of speech. You must have a very good command over, you see, verb. There are different types of verbs. You need to know adjectives. And you also, there are different types of adjectives. Then different types of verbs. And different types of subverbs, auxiliary verbs. In other words, a very good command over grammar. Because simply because an auxiliary changes, the meaning of the syntax will change. Even if the main operative word is the same. Shall do, will do, may do, might do. What is changing? Auxiliaries. Not the verb. Verb is the same, do is verb. But there are 4 auxiliaries that I gave you. What you can say is this, that yes, these auxiliaries have these meanings. But the meanings of these auxiliaries, if you refer to any English dictionary, any English grammar book or usage, is not the same. So this is the importance of Vakya principle that we know from Mimamsa principle. Let us come to more specific aspect of context as far as, now we come to English. So we can be more sure about the language that we speak. Once we know the text in Sanskrit and then we talk, I think in all our humility we must admit that there may be imperfections when we are speaking in English about something which is originally in, so whatever I have said about Mimamsa, take it with a pinch of salt. There may be text referring to a little different or varied meaning of what we have discussed. But this is English, there is no problem about it. Context, let us make a very general remark. Now, here was a case that went to the Permanent Court of International Justice between Poland and Germany. And this was about concerning the interpretation that had to be given to the Treaty of Warsaw. Now, International Court of Justice, in the context of resolving this dispute, stated this cardinal principle, that it is a cardinal principle of interpretation that words must be interpreted in the sense which they would normally have in their context, unless such interpretation would lead to something unreasonable or absurd. there are a couple of things that you need to note. Although this is a historical, you see, statement made in 1925, still there is a relevance, indeed a continuing relevance of certain expressions, certain thoughts stated as early as 1925. The first is reading a word or a sentence in a context is a normal rule. This is not an absolute rule. If you read a saying in a context that you genuinely believe to be a context, and the meaning that you get is absurd or unreasonable, well, these two concepts, I'm not leaving it, I'll be surely addressing it. But the point is the plan, the structure that I have devised of these lectures, in my structure of things, it would come in the supplementary means of interpretation. So we leave it. So for the time being, just assume it and allow us to continue. What is unreasonable and what is absurd, that we will see later on, and when we discuss maybe lecture 10th or 11th, 10th or 11th will come. But what is clear and what is certain is this, that to read a text in the context is a normal rule. But this is not a non-derogable rule. This is not an absolute rule. And whether, even if the text gives you an unreasonable meaning, even if the text gives you an absurd meaning, you are bound to refer the context. That is not the case. So this point is well taken, because when we see Vienna Convention on the Law of Treaty, that is the international law followed everywhere, this also admits of the same proposition. Article 32. So this much is very important. So this is the general point of a context is that, in other words, the prima facie burden on the interpreter is to show that he has referred to context, he has referred to the ordinary meaning of the context, but the meaning that is given after reading the context is unreasonable or absurd. Only then may you ignore the context. So in other words, it is like this. It is not the end. That alone is important. Certainly that is important. But whether the end is genuine or false is to be determined by the process that you have followed. For instance, you have never looked to the context and say it, there is no need. The meaning that I get without context is perfectly fine. This is one thing. This is another. I have looked to the context, but the context gives me an absurd meaning. And as an interpreter, I am not allowed to effectuate absurdity. And that is why I ignore it. There is a difference. You don't look at and conclude that the text is, the meaning that it gives is alright. You look to the context, see the meaning in the context, you are convinced that it is an absurd meaning, this is an unreasonable meaning, and then you ignore it and read it without context. Because reading without context makes sense and effectuate it. So in other words, as I told you in the beginning, then interpretation is both a noun and a process. Is a verb. So we can see that it is the process which is also, or which is as much important as the end. Without referring to context, it is not permissible to say that the context gives an unreasonable and absurd meaning. This is the duty of the interpreter. It is true that most of the time the interpreter is the court. Most of the time interpreter is the adjudicator. And the problem of adjudicator is Then adjudicator is there to adjudicate, not to teach like us. I know I wrote it, 2004, a sentence that I should tell you. And I quote from my own book. The principal purpose of adjudication is to resolve a dispute rather than to write a coherent essays on jurisprudence. They do not tell you always the process. Because they have to decide between the two. Here is one counsel, here is another counsel. And they have a long list of cases. So they do only that much that the case is disposed of. And if there are gaps, for instance, whether he has referred to the context or not, but if he has stated in the judgment, then this meaning is absurd. So you have to accept it. There may be a logical disconnect. You do not find in the judgment, then there is no evidence whether he has referred to the context. But he is saying it. He is the judge. You have to accept it. You don't believe it. If it is a high court, then of course there is a possibility to go to Supreme Court. If it is Supreme Court, then possibilities are very limited. Curative petitions or constitution bench and whatever. It's very surprising. Have you seen the Subramanian Swami's recent moving to the Supreme Court? The day before, Wednesday, he moved to Supreme Court. Yes, absolutely correct.
And contain that article, section, IPC section 401 the violation of the article 1979.
Excellent. I appreciate a student who is being a law student. You should actually read such things. This is an absolutely correct understanding of what it is. In order that his complaint is quashed, he went to the extent of alleging that sections 499 and 500 are unconstitutional. You know what did he say? This is only tactical. He knows it. He is a very qualified person. If anybody else is saying, and that's why I noted it. If anybody else is saying, then you ignore it. The sole reason he said it, then Supreme Court should admit it. That's it. Even if after 5 years he knows it, he's going to say, well, on facts we may give you this relief, but these sections are not unconstitutional. But to put it conversely, if he did not say it, it would not include even apparently a law point. And the chances on facts to get an SLP admitted or any application and any petition to go to Supreme Court are very bleak. So in order to bolster a claim, sometimes people went to the extent of something which in principle is admissible, while on facts is totally nonsense. If you see 499 and 500 is punishment. 499 you see is basically the substantive provision. Is very clear. You allege something which is false, which is defamatory. And what is defamatory is basically to be measured on the basis of somebody's repute. Well, everybody has his own assessment of own esteem, but there is something very basic. Reputation does not mean that you must be a Nani Palkiwala. Reputation does not mean that you must be a Narendra Modi. Let me tell you what is meant by reformation and what is reputation. Very simple, and you'll be surprised to see how basic thing. You got an LLB degree. Somebody tells that you are an LLB fail. This is defamation. This is a violation of your, reputation. Don't you think so? it makes you, in the eye of people, that you are not a law graduate. Just think about it. Because after having, you see, an LLB degree, there is some reputation that you acquire. Otherwise, if there is nothing is acquired, then a person who has a high school degree is equivalent to somebody who has a 12th degree, is equivalent to somebody who is BA degree or LLB degree, or you see, that means these degrees are merely bunch of papers. It doesn't matter. For instance, somebody says that you are a criminal. So the point is this. These are, you see, very, very important things. And if there are conditions, there are exceptions, several exceptions. You say that I said it in good faith. You say that I said it in public interest. You said it that I only communicated it to this person. I said it on the phone, and the phone was heard only by this fellow. This was not communicated to somebody else. Well, those things are different. But the point here is, he said it in order that this should go to the court and should be entertained. Maximum chances be entertained by Supreme. So this is very important when you say, you see, that context does not mean that it must be an inflexible guide to meaning. The entire law of interpretation, and there are several tools to interpretation, are merely a facilitation. And no facilitation, a facilitation is a facilitation only insofar as it remains flexible. A facilitation that ceases to be flexible and becomes inflexible hardly remains a facilitation. Then there are, you see, when you talk about context, then there are several presumptions. Of course, the treatment of the subject has not been as clear, because approaches to interpretation on the domestic plane and on the international plane are not always identical, and there are different variants. For instance, you find on the domestic plane that maxims such as this, they are called maxims. They are called internal aids. Very rarely do you find that these are also referred to as contextual presumptions. It's a very simple thing. Why? Because we have seen it, it is quite possible that you refer to a context and get a meaning which is absurd. Something which on facts is simply not possible. Now on this point that you see that there are presumptions which are very well known to students of this subject, as far as I am aware of this country's students. This presumption is, for instance, a presumption which is called nocere associi. So this is a Latin expression. What it says is this: sometimes in a sentence you find that there are general words and there are less general words or more special words. Now, problem sometimes is then there are cases which go to courts and the lawyer of one party is relying on general word, saying the general word should get the meaning from a special word, and the other lawyer is saying that a special word should get the meaning from general word. And it is not a question, because lawyers do not basically go to courts for their intellectual advancement. Today a lawyer is saying the same thing, and tomorrow he has another brief, he will say exactly the other thing. And when you ask him outside the court, yesterday you were saying this, today you are saying this, you know what will be the reply of the intelligent lawyer? He will say, tomorrow I had a different case, today I have a different case. Yesterday I was arguing that case, today I am arguing this case. The fact that yesterday only I was arguing and the fact that today only I was arguing doesn't mean that two cases are same. I am basically here to argue. That is how If you can't compartmentalize your mind in such a manner, you can't be a lawyer. You know the famous maxim of Ram Jethmalani? To a lawyer, foolishness, there is nothing but foolishness in consistency. Consistency is not a virtue of lawyers. Why? They had a different case. We had argued Jayalalitha's case. And I am sure he is going to argue again. What better lawyer they will get? So the point is very simple. The point is very simple. And these things happen. And both the lawyers can say that, Your Lordship, here is this. This is the general word. And here is a special word. So the person, you see, saying that, that the special word, the meaning of the general word should be given on the basis of the meaning of the special word, will cite this maxim. Now, look to the court. This presumption, this maxim, is not a rule of law. Please try and understand this. This is not a rule of law. That the meaning of the general words is confined to the meaning of the associated less general words. You tell me where is the rule of law? Who enacted this? It is basically a presumption. Now, if you make an inventory of those cases in which this maxim was applied and this presumption was upheld, it does not become a rule of law. If an act is repeated 20 times, does it become a law? Not necessarily. It may well be a case of violation, and that violation may have gone unnoticed. Well, you may say that, who was that policeman? Who was that ticket checker? Who was that traffic policeman? But you can't say that, well, I never stopped on this speed breaker for the last 20 years. You say that is fine. But today you have to pay fine. I never purchased a ticket in TTC bus. Ever since I am a student of South Asian University or JEE, I have seen some of the students when I was a student there, then we never purchased. Is that fine? Today you have to purchase and give a fine of 50 rupees plus. So that is the whole question. If you make an inventory of the cases, that is what you see Justice Scalia. Justice Scalia's argument is very convincing that most of the books on interpretation, they ultimately end up as an expert witness. You know what they do? Their methodology is very simple. You are a law student, you should also understand in between the important points. References are there to corroborate a point. I am not here to tell you these cases or those cases. That is all for which I am invited here. Believe me, there are many people who can do this. Or you can yourself better do it. You all know how to use search engine in Supreme Court cases and whatever, all others, this Manupatra and all kinds of things. References are basically tools to underscore a point. They are used only to the extent that there is a point to be illustrated. The methodology is that you write this maxim and cite, make 20 cases and then conclude if the meaning of if less general words are associated with general words, then the meaning of the general word should be confined to less general word. The student is made to believe as this is a rule of law. Because here is a book which says that this was done by Supreme Court in 25 cases. Another author that you should remember, Professor Carl Levlin, immortal person on this point. Nobody has done that level of research. You know what did he do? He did what no other author did. You know what did he do? In order to rebut these presumptions, he made another list citing that these are the cases in which The general words did not take the meaning from less general words. Now what do you conclude? The point is this. You should illustrate a point, make students understand in the art of interpretation. But do not even by inadvertence, even by gestures or even by acts, communicate to them what is not a rule of law. It is merely a presumption. Presumption is a presumption. It is neither a rule of law as a matter of substantive law, and as a matter of procedure, evidence is not equivalent to proof. So it is my duty to tell you that there is a presumption, but it is also my duty to tell you what it is not. What it is, you know. Most of the students know, you is taught. But the more emphasis in this class is what it is not. It is not necessarily to be the case. But if I did not tell you, then you might think, well, whether or not I should have told you. So in my endeavor to tell you this thing, I want to emphasize is this. Yes, this is a very good presumption. And yes, there are cases in which the Supreme Court, several courts, including Indian Supreme Court, has done it, and you can see the example of the case that was referred to. I gave this case to you because it is only in 4-5 pages. So I thought that when I give readings to you, I make sure that reading should not be in many pages one can read these pages. Now, here was this case. This case was before the Supreme Court, and the issue was whether, you see, how do you actually constitute this perfumery. There was an expression, perfumery in a statute, and the dispute concerned perfumery of the type which is used for religious purposes, like dhoop and agarbatti and all that. So the court said, fine, we know that the agarbatti also smells like a perfume, or in that sense there is an essence, there is a perfume in an agarbatti. But perfumery, you see, is a much broader. There is supposed to, there may be cologne, there may be a cream, there may be several other. We do not know how many types of creams you can smell, and you will give you some perfume. So in that case, in this particular case, Supreme Court said, well, on the facts of this case, we have to limit the meaning. We have to find out from the words, the facts before the case. So in this particular case, the Supreme Court said, well, this is not going to include dhoop and agarbattis. Even if there is perfume in dhoop and agarbattis. This is the importance. What do? There is a fact before you are a judge. You know that the case, the facts predominant is nothing to do with cologne, nothing to do with aftershave, nothing to do with ponds, nothing to do with all these face creams and nothing like this, shampoos and all other perfumes. The case before you, both the parties, respondents and you see petitioners, both, they are contending these agarbattis religious articles, articles which are used for performing, you see, pujas and all that. Now you tell me, how can you ignore these facts and say that, well, I know the meaning of perfume? You don't have to see all these, this is a dictionary, open it. If you open the dictionary and give the meaning of perfume in every case, you know what is going to happen? This will be totally nonsense. So merely, you can see it. So here is a one case where you can see, you see, then this presumption worked. This is the case where this maxim applies. But this was held to be correct. Why? Because the facts of the case supported, allowed for the application of the maxim. Facts actually testified. Not that maxim allowed you to resolve the case. That is very important to note. Another presumption, another maxim. Because I have selected some of these which are very well known. Law students, I am sure, from LLB background, I can't believe it that they are not aware of it. But the only point that I am not 100% sure whether they are also told the limits, the limitations of these maxims. What these maxims are not. They are told as though these maxims were the rules of law. This again is the same thing. The only difference is the less general word is of a more specific kind, of the same genre, same genus. That is the only difference. So the category of less general word is further confined. That is the only difference between the first maxim and the second maxim. Both maxims are contextual maxims. Both are presumptions. Neither is a rule of law, even if both have been followed in many cases. You have example of this as far as Indian Supreme Court is concerned. You can see this, the application of this maxim in a case where the court had to decide the application of the meaning of the word administrative action. So the court is saying that there is a possibility, because if you see the provision, it not only says administrative action, the provision also says any other manner. So in any other manner, even if out of, you see, common sense, suppose you do not know this maxim. Now tell me, how do you interpret these two expressions? Administrative action and any other manner. You tell me what is broader, what is less broad. You see, the fact that any is used, any means all. Why do you use any if it is meant all? You know the reason? The reason is any can be both singular and plural. That is one advantage. The second advantage of using any is that this is inexhaustive. You don't have to enumerate. Because all implies exhaustion, counting, which any does not. That is the advantage. But in terms of interpretation, there is no doubt about it. Administrative action, of course, it is only one manner, just one manner. If there is an administrative authority, it is taking action. Administrative authority may have taken one action. That may be an administrative action. But that authority may have taken several other actions. For instance, if there is an act, and indeed in this particular case there is a corruption case, and you have this Jayalalitha case, and you can compare this. If an authority is a public authority, you are exercising public functions. If you see, we have referred in this interpretation class the meaning of the term public servant with reference to corruption, 1980 Act. If I correctly remember, it's defined in section 2C. You see the long list. The fact that you are a public servant and you can escape action simply because you say that what you did was not an administrative action. And if it was only an administrative action, and only then you catch me. No. If the statute said any other manner, you know what? Because you read any interpretation or any illustrations, word any is of a very, very broad amplitude. If the word any is used, it is very difficult for you to say that this is not included. Any other manner, indeed, manner is a loose term, and if it is qualified by the word any, it goes, to me, the reference to the expression any other manner is very broad. So therefore, you see, one can see that these maxims are basically presumptions. They are not rules of thumb, they are not rules of law, and even if one can cite you 1,000 examples, it will not become a rule of law. These are basically presumptions, which is basically not well communicated to students, and which it is the duty of, well, these are eight, certainly, courts have used it, but these are not rules of law, they are basically presumptions, and they may well be discarded by the court if, on facts, the application of these presumptions would be totally unreasonable, totally absurd. And that is what, remember, you see, generally in that particular case, police service case, permanent court said it, that is a general thing that you refer to context, but it is quite possible that your reliance on context may render the meaning inaptly, the meaning absurd or unreasonable, and then you proceed. Shall we take a break and then we come back? Now let us see the operation of context on the international. On the national plane, we have seen that this has certainly been mandated, say when a situation should arise, when the meaning upon reference to context turns to be unreasonable or absurd. With the international law, we have for the first time a law, first of all. Thus far, the first distinction that you see, the discussion before and discussion henceforward, is that the discussion on context before and thus far is not on a rule of law. There was no law. There were examples, there were presumptions, religious text, and then on that basis a reference was devised, the necessity was felt of referring to context. Here is a law, and that law is the form of a treaty. Treaty on the international trade, international plane is the most important manifestation of law. There is no more important a form of a law than a treaty on the international plane. Now what it reads, I will also help you in reading this provision, which is very important. This provision is again, you see, Article 31, paragraph 1 of the Vienna Convention on the Law of Treaties. This says, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context. Now please try and understand. Do you understand context of what? Read this provision so that I should also know whether you are learning it or not. If you merely read it, reading is not always and necessarily coterminous with understanding. So it is very important that you context of what?
Same sort of particular circumstance.
No. Any other answer?
This is the context in the context in which the treaty was entered into.
Okay. But this provision doesn't say that. Read it again. A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context. My question is, context of what? Exactly. You see, it is very precise. And the answer is terms. The answer is terms. So in other words, my question was not inappropriate. My question was not using gratuitous. It was an important question. We are referring to context. It is my duty to ascertain from students whether you are understanding context of what. We may end up discussing context in the next 45 minutes or so. So many slides we see. But we must first understand. As far as the Vienna Convention is saying, it is saying context of the terms of the treaty. The operative noun is for context. The operative noun is terms. For terms, operative noun is treaty. You try and understand this importance. In other words, treaty is no context unless, as far as this provision is concerned, and simple grammatical English, simple plain English, nothing more than that English grammar I am telling you, unless it must be through the terms. Treaty is just one sentence, Vienna Convention and Law of Treaties. What do you get? This is the name of the treaty. Here is the name of the treaty. So how do you know the context of this treaty? The context of these terms. You have a burden again. You say that through these terms, I go to the context of Vienna Convention, and from Vienna Convention's context, I go to some other treaty. You try and understand. But please try and understand. The sentence is, for context, the operative noun is terms. And for terms, the operative noun is treaty. So in other words, you cannot directly go from context to treaty. You have to go through terms. And that is basically the importance. You see, this is the letter of the law. You have to notice even comma. I always emphasize to students, if a law is written in the English language, it is not English. For the same reason, if the law is written in Malayalam, it doesn't become Malayalam. It remains law. Law remains law whether it is written in Malayalam, whether it is written in Kannada, whether it is in French, whether it is in English. Sometimes people read law as English. That is their problem. Please, for God's sake, this is not English. This is law. Their context, it is the terms and the context we are speaking as far as Vienna Convention is terms. So the first question is terms. For context, the operative noun is terms. What are the terms? For sure, all words, punctuation, anything that is black on a white piece of paper. This is the most simple and you see comprehensive answer I can tell you. Vienna Convention and Law of Treaties, and anything that you find is written in black. Whatever black dots, and suppose you are an illiterate person, whatever black you find are terms. All dots, all scribbling, anything, that helps. And you may go beyond these. After verifying, you have a burden to prove then how do you go beyond these? Because the law doesn't allow you to go beyond these as context. You have to first count terms and then discount them with a reason. Then these are unreasonable, these are absurd. That is the first thing. That is I wanted to verify whether you read it. My request to you is, when you read a text, written in whatever language, please, language is a vehicle. Language is a means to understand the law. And even after using that language, please note it that we are not conducting an exercise in the English language. We are certainly, I am not qualified English teacher. So I have no authority. In fact, I am not law teacher, I am English teacher. I can't tell you anything about English. I use it as a vehicle. So this is basically law. Let us now come again to Vienna Convention. So we have concluded that it is basically the terms of which we are referring, we are discussing the context. Further, let us take some illustrations. What does the Vienna Convention say further on context? The context for the purpose of the interpretation of a treaty shall comprise, in addition to the text, including its preamble and annexes. Now you please tell me, what do you understand? Yes, you use the microphone so that we should hear exactly what you are saying.
That means there are only two contexts. That is preamble and annexes. The terms can be interpreted or understood in the context of preamble and annexes.
Any other understanding?
That means terms can have different contexts. Like you were giving an example that a professor was saying something in a lecture hall, a professor was something in tea hall, that professor may say something in a lawn or in a garden. So terms can be interpreted in different contexts. But for the purposes of the VCRT, that terms will be interpreted in the context of preambles and annexes. The context will be the preamble and annexes only, not otherwise than that.
What he is saying is this: Vienna Convention says then context means only two things. One is preamble and another is annexure. Is that what you are saying? Yes. That's right. Fine. Any other example? Any other meaning of this? Read it, and then now you will find it how difficult it is to read law. I have no doubt that you can read it as a matter of English. Anybody can read it.
Sir, I think in this statement, in preamble and annexures are also included in the text of the treaty. I mean, in addition to the text, including its preamble and annexure, it means something other is there.
Yes, it is a better answer.
We can interpret it with the help of three things: text, preamble, and annexes.
Is still something in this. You see, do you note it? First, you see the three dots. You have not read those three dots.
Something more.
Exactly. I request you always, as a law student, see, that is very important. First of all, context Vienna Convention is saying is more than, if in one simple sentence it can be said as, context for the purposes of Vienna Convention is more than text, preamble and annexes. In other words, of course, these three are context. There is no doubt about it. But context, if you see in a Venn diagram, you bigger circle and then you make three circles. One has context, annexes, and you see preamble, and then you represent it. You see that Venn diagram. In other words, well, of course, these are there. These are context. But context is more than this. And now you just allow this to sink in your mind that even if context is something which is more than this, so is it less to have the text, preamble and annexes, and this is not enough for context. There is something more. What is more? I will show you. Let us take the example of. So first thing that you notice in an abstract, that context certainly includes preamble, annexures and text. But context is not limited to text, preamble and annexures. What is the importance of writing this in the specific in the Vienna Convention? To highlight it more, to give a more specific illustration. It doesn't mean the Vienna Convention is exhaustive, because again note the word including. In other words, it is merely citing these. It is not just saying only. Including. It means something more than this. Let us take the example. This example. I gave this example, you see, so that I think it is clear. Because this is a talk, this is the text that you will certainly read as part of your curriculum. I'm not sure whether doing this year. This year not doing trade law. This year what is something that you have jurisprudence, law of the sea,
international law, jurisprudence and legal.
methodology.
Legal research, jurisprudence and legal research methodology.
Is one paper.
Yes.
Jurisprudence and research methodology one paper. Second paper is
No, sir. Jurisprudence and legal theory.
one paper, okay.
And
Second is research
methodology.
Second paper.
International law and fourth one comparative constitutional law.
Okay, you have international law,
Yes.
private international law,
No, international law.
public international law, and then you have
Comparative.
comparative constitutional law. All right. So I'll bear in this mind so that whenever I give illustration or examples, so I'll bear this in mind. But this is something we're going to do next semester. Now, if you see the preamble as an illustration, because it has been specifically mentioned there in the Vienna Convention, although it is not exhaustive, but it is specifically mentioned, so I have to give a specific example. Here is a preamble. I have taken this example from the preamble. Again, you can see dots on both sides. In other words, there is something before it, there is something afterwards. So even if the preamble of the World Trade Organization agreement is not this one, there is something more to it. But I have, you see, taken this syntax only to emphasize, because what is going to follow in the example, in the case that I forwarded to you. The optimal use of the world resources in accordance with the objective of sustainable development. So in other words, the preamble to the World Trade Organization's agreement also talks about, also, because there are dots, also, there's something more than this. Optimal use of world's resources in accordance with the objective of sustainable development. So this is, you can see, this is stated in the preamble to the WTO agreement. Now, this preamble was used by the WTO appellate body for the purposes of interpretation of GATT treaty. So you have, we saw Vienna Convention, we saw that preamble is a context because it has been specifically mentioned, although it is not the sole context or exhaustively the only context. And now we see the example of a preamble. So we have seen the example of preamble in the form of the preamble of the World Trade Organization. Here we see the example of its use in the interpretation of a treaty, and that treaty is the General Agreement on Tariffs on Trade, more specifically Article 20, subparagraph G. Now in this case, do you know that, did you have the chance to read this case or have otherwise heard of this case? This case, there was a case, this was a case between the United States and India, on the other hand Pakistan, Thailand and Malaysia. Four countries. So there. Now what the United States did was, United States imposed a ban on importation, means export from countries which I named, to United States on the ground that these countries caught shrimp by using a technology which was indigenous and which necessarily killed turtles. Turtles, according to the United States, was an endangered species and was therefore required to be protected by the United States, because United States was a signatory, indeed a party, to the 1973 CITES Convention. Now, these countries, challenged this ban. These countries said, well, this is a ban which is totally arbitrary, which is unjustifiable, because there is a too remote a connection between shrimp farming and conservation of turtles, endangered species, and these two have no nexus, and this they believe that in the name of the environment protection, United States basically want to discriminate against the shrimp originating from India, Pakistan, these regions. Now the case went to the WTO panel. WTO panel ruled in favor of these countries, saying that, well, environment protection is good, but then I can't use environment against these countries. You can't use environment against trade. That is what how the panel said. I am using a very rough language. I don't want to be quoted because it will become more technical if I cite you the paragraphs and more. This is basically the thrust. The thrust was the panel ruled in favor of this country, saying that you can't use environment against trade. That is the way. United States got offended, saying that what is this nonsense? You don't respect environment, this and this, and appealed against the panel ruling. And that is how this case landed up before the appellate body. Appellate body is the Supreme Court of International Trade. So that is why it is before. Now, United States cited preamble in its pleadings. United States cited pleadings. In the pleadings, United States cited this provision: optimum use of the world's resources in accordance with the objective of sustainable development. United States said turtle is a world's resource, and if it is a world resource, then it is to be used in accordance with the principle of sustainable development. These countries said, well, the provision that was cited by the United States for adopting Section 609 of the 1974 Act, Trade Act, to impose a ban was Section 20G. Section 20G talks about conservation of inexhaustible natural resources. These countries said, India, Pakistan and others, turtle is not an inexhaustible natural resource because it is replicable. This is the living resource. These countries thought inexhaustible means coal and something which is not replenished. And here, the issue before the appellate body was essentially this, do you believe turtles to be an inexhaustible natural resource? And if you do, what is the treaty justification for you for interpreting a living, in this case specifically turtle, to be an inexhaustible natural resource? This was the issue. Now, in order to reach this conclusion, the appellate body said this: from the perspective embodied in the preamble. Now you can see how preamble was used. We note that the generic term natural resources in Article 20G is not static in its content or reference, but is rather by definition evolutionary. You see, appellate body said this: Article 20G was the same as it was in 1948 and as it was in 1998. There was no meaning, there was no amendment to Article 20G. When GATT was adopted in 1930th October 1947, put into force on 4th January 1948, the expression of Article 20G was the same. But what happened from 1948 to 1998 was that the preamble changed. In the preamble to the GATT, it was written full use of natural resources, and there was no reference to sustainable development. By the time you reach 1998, there came a preamble of WTO, which did not talk about full use, but only talked about optimal use, and which also contained sustainable development. So, again to summarize, the natural resource word was used in Article 20G, which was not amended, which remained as it is. But during these 47-50 years, the meaning of natural resources changed with reference to preamble. That changed. Text, terms did not change. The direct interpretive word natural resource did not change. The context changed. Context change. In the context of 1947, there was full use and no reference to sustainable development. This was the context. The context in 1998 was optimal use and with sustainable development. The result was the change in the meaning of the term natural resources, so as to include even a living natural resource in the meaning of inexhaustible. Inexhaustible natural resources, double adjectives. This is how you can see. Unless you read like this, you will not understand. There is no way, no other way. Simply reading in a book, then this is context, this is this, that is, you can't understand that. Law is not a history, or it is not a subject that I say it and you believe it. No, it has to be understood. Look at it, the same expression and how it was changed. So in other words, the term natural resource, even if qualified by a further adjective called inexhaustible, was rendered useless by the adoption of two terms in the preamble: optimal use and sustainable development. These two terms changed the literal meaning. Indeed, it rendered them totally useless. Dictionary meaning English language, the word inexhaustible doesn't mean anything. because the reference totally robbed them of any meaning. They simply became meaningless. Exhaustible natural resource, inexhaustible natural resources absolutely got meaningless. What happened? You can see it. This is the simple. And you coming from India and from Pakistan, these students must be. And there was a conscious choice that I made in sending this to you, because you are South Asian students, university students. Your countries, two countries from South Asia, were participants. You can see it very closely that the word inexhaustible natural resource was there since 1947. But by the time it came to 1998, even without amendment, inexhaustible was rendered meaningless. So it remains there, but it has got no meaning. It is simply useless. Because the appellate body is saying this includes both. Whether it is exhaustible or inexhaustible, it doesn't mean anything. Why? Because optimal use. If optimal use and sustainable use is to be made, so where is the difference between exhaustible and inexhaustible? It doesn't say that exhaustible should not be made sustainable use of, where exhaustible should be made sustainable use of. It doesn't say anything. In other words, preamble doesn't distinguish between the nature of exhaustibility. It makes no reference to exhaustibility. Therefore, it has to be referred as it is. This is one example. So, example, you have seen example of preamble as context. You have seen one example. Let us see the example of annexures. Now, again, Vienna Convention, because annexures are mentioned specifically as context. So you have to, it is my duty to tell you specific examples. Again, I should not introduce any other treaty, same treaty. You have World Trade Organization agreement and you have annexures 1 to 4. Annexure 1 is labeled as multilateral trade agreements. And there are 13 multilateral trade agreements as annexures. Annex 1A has 13 multilateral. Annex 1A is GATT 94. Then you have agreement on agriculture, agreement on textiles and clothing, agreement on technical barriers to trade, agreement on sanitary and phytosanitary measures, agreement on anti-dumping, agreement on safeguards, agreement on rules of origin, agreement on customs valuation, agreement on pre-shipment inspection, agreement on subsidies and countervailing measures. These are agreements in 1A. Then you have agreement Annex 1B. Annex 1B is General Agreement on Trade and Services. Then you have Annexure 1C, Agreement on Trade Related Intellectual Property Rights, TRIPS Agreement. Then you have Annex 2, which is Dispute Settlement Understanding. Then you have Annex 3, which is Trade Policy Review Mechanism. Then you have Annex 4, which is Unilateral Trade Agreements, Agreements on International Dairy, Agreement on International Bovine Meat, Agreement on Civil Aircraft, Agreement on Government Procurement. These are 4. Can you see the number of annexures to just one treaty? Just one treaty. I am not aware of any treaty in the world to which are annexed so many agreements of so much importance. And that is why I gave this illustration. All these annexures, you know the implication of this for the purposes of your class. That was the example. This, what follows now, is important. That is the lesson. The purpose is not that I should write 20 things back home and show it to you. Without my writing, you know it, all these things. These are available freely. Yet, the lesson is this. All these annexures are context for the purposes of interpreting the terms of the World Trade Organization agreement. Can you imagine? Now you can see why interpretation is so difficult. So if you are reading one sentence of WTO agreement, so you know it. Then look at it. There is one sentence, but the annexures, context is, it is like this. The text is one sentence, but context is hundreds of pages. At least if I should tell you the total number of pages of these are more than 545 pages. 545 pages of hard law. Just one simple bare act, one notification. You study for months to master that. And here is 545 pages of annexures. This is another example. Yet another example of annexures. You have annexes 1 to 4 of the agreement on provisional arrangement in Afghanistan. That is again I chose it because I know, well, you have students from Afghanistan, whether or not they are usually part of. Do you have students from Afghanistan in this course?
Yes.
First year LLM students?
Yes.
They are not attending this. Well, of course. I deliberately chose it. Whenever I have to make a choice of examples, I always find out whether there is an example from Sri Lanka, Nepal, Pakistan. That is why. Well, you have this, this is good for me, I don't have to elaborate much. You see, provisional arrangement of Afghanistan pending the establishment of permanent government institutions. That is the very famous Bonn Agreement of 2001. So you can see annexes 1 to 4. So these annexes are certainly context of the interpretation of this agreement. The terms of this agreement may be interpreted in the light of these annexes. Now, so you have seen specific examples of preamble and annexes. Now again get back to the Vienna Convention. What is other that is also included as context? Vienna Convention says treaty connected agreement. Any agreement which is connected to the treaty is also a context. What does it say? See the exact provision. Any agreement relating to the treaty which was made between all the parties in connection with the conclusion of the treaty. That is also a context of the terms of the treaty. Example, you have understanding relating to Articles 1, 2, 3 and 8 of the Convention on the Prohibition of Military or any other hostile use of environmental modification techniques and MOD Convention of 1976. So here is an example. These understandings are not understandings, they are agreements. That is why I told you in the beginning, when you read in English a legal statement, please see it, understand it as law. So when you read it understanding, and remember in some other class I told you, forms of interpretive text. This is not understanding, this is written as understanding, this is an agreement governed by Vienna Convention and therefore is a context. Then Vienna Convention further says treaty related instrument is also a context. The exact provision is any instrument which was made by one or more parties in connection with the conclusion of the treaty and accepted by the other parties as an instrument related to the treaty. This is also a context. Example, 12 agreements annexed as instruments which were made by one or more parties in connection with the conclusion of the General Framework Agreement for Peace in Bosnia, Dayton Agreement, and accepted by other parties as an instrument related to the treaty. Here is an example. If you see Dayton Agreement, you will find that there are 12 related agreements. That on military front you will do this, on telecommunication front you will do this, on this front there is this understanding, on this front there is this understanding. All these were signed and concluded at the time of signing the treaty. This is also context. Now, context, if you make a conclusion on this whole topic, first of all, we make a preliminary conclusion on Vienna Convention. Vienna Convention, in all, is specifically states specifically only 4 contexts, but I tell you only specifically, which means that these 4 examples are not whole. And if this is not the whole, because these 4 are too much, you have preamble, you have annexures, you have treaty connected agreement, you have treaty related agreement. And all these are not all what is meant, what is permissible under the Vienna Convention to an interpreter to rely for the interpretation of an interpreted text. So you can imagine the extent, the compass of context. This is to be true. It is not possible to put it in exhaustive limits. Let us make some conclusion. A text is required to be interpreted in its context. At least this much we can agree. You have to agree the text in the context. If you don't agree, then you have to give reasons why. 2 permissible reasons that we find in the unwritten law so far, because written law will discuss on this, that will follow this structure that we have to follow. Unreasonableness and absurdity, I will explain. I told you that doesn't fall in today's discussion. It will fall. It will come. That we understand. Second, the context of an interpreted text may extend to various forms of text, both within and outside of the interpreted text. This second statement summarizes the Vienna Convention. Why? Because annexures and preamble are part of the treaty. They are within that treaty. Within. But treaty related agreement context and treaty connected context, they are beyond. So in other words, within the terms of the treaty, you can find context which is within the terms of the treaty. And then you can also find contexts which are beyond. So in what you can say roughly and loosely, context inside the treaty and context outside of the treaty. Third, determination of the context of an interpretive text is not always and necessarily inseparable from an interpretive choice made by the interpreter. The important word to remember is always and necessarily. I am not saying there is always a choice, but what I am saying that sometimes there is a choice. That after relying on, you say, preamble, after relying on annexures, treaty connected agreement, treaty related agreement, beyond these 4, because they are not specifically mentioned, and then there may be a choice for the interpreter. As far as these 4 are concerned, there is no choice. They have to say, well, I read it, I referred to it, and this is not what is going to lead to a reasonable conclusion. But beyond these 4, then of course, because these are not mentioned, you can't challenge him, then why are you referring? He said, because Vienna Convention says including. He is going to say, I am not prevented from going beyond these 4, because I am allowed to rely on Vienna Convention. Vienna Convention allows me. So you revert it, then you are not allowed to do this 5th treaty as a context. Well, this is also a context. So that is an interpretive choice here. So when we say that interpreters sometimes, you see, do exercise some choices, it is not that we can say is in isolation from the relevant text. After having studied this, after having studied and seen the examples of Vienna Convention, only then it is possible to say that there still exists an interpretive choice. In other words, interpretive choice that is exercised by an interpreter also includes in the choice of making reference to context, choosing a context beyond those four. Because Vienna Convention allows for it rather than prohibits it by its express use of the word including. That is what all I wanted to say today. You are most welcome to put questions if you have any. Please clarify, because if you clarify the same day, it is very easy for you and also very easy for me to respond. Yes.
So, preamble, annexure. First is preamble, second is annexure, third is treaty connected agreement, and fourth is treaty related instruments.
Yes.
These are the only four contexts for the purpose.
No. No.
So even if they have been expressly written as the context,
These
there
are not the only forms of context. These are not the only forms.
they are written form.
These are specifically written forms.
So
Don't say these are the written forms.
specifically written.
Yeah, you have to use an adverb. Then the sentence will become correct. Why? Because other written forms are not specifically written, because including is written.
You can say specific.
You see, it's like this. It is like this. I make a statement. Other male students are also welcome. Then Mr. So and so, Mr. So and so, and Mr. So and so. So, do you know what does it mean? No male student is excluded, even if nobody is named other than three. They are not named. Other contexts are not named, but they are included. And which are not named, why? Because they are infinite. If they were finite, they could have written it. Why? Do you believe that they did not have a piece of paper to write? There were not enough piece of paper for countries who were negotiating Vienna Convention. There was lack of paper. Just give me what was the problem? The simple reason was either there was no agreement. Some said you include these two. Others said no, I don't want these. You include these three. So they said all okay. What do we do? On which everybody should agree, we write it, and then other we say by including. There are only two possibilities. If they have written it specifically, it means then everybody agreed, because everybody has signed. But everybody has also signed on including, and it is not expressed. What does it mean? There was definitely disagreement on naming them, but not disagreement on including them. You see, that is why interpreting a word, and that is what is clarified by question is this. What is doubt in your mind is clarified only when you ask a question. Because I have no doubt about it, so why would I say it?
So sir, which one will get privacy or which will be the most appropriate context?
Yes, that is very important. First of all, the answer to this is, as far as Vienna Convention is concerned, Vienna Convention gives no primacy as far as these four are concerned.
And these will be the most appropriate context.
These are definitely the context. Vienna Convention doesn't say that in every act of interpretation you must refer to these four. That is another interpretive choice. An interpreter said, well, I have, for instance, appellate body only relied on preamble. You can say, why didn't you rely on the other three? You challenge them. You know what will be their counter reply? Where does Vienna Convention say you refer to all four? See, you try and understand the problem. Where does the convention say Then you refer to all four. Appellate body will say, look, you came to me because you had a problem with other country. I solved your problem. Where have I accepted the teaching assignment that I should teach you? That is not my job. My job is to settle your dispute, and I did not come to you. You came to me. I settled your dispute. Now you go home. If you want to understand it, take lectures. That is the whole thing. The adjudicative bodies, the answer is, we are here to solve your problems. We are not here to, do you know the difference? Doing a postmortem, the doctor will do the postmortem, and the other stitches are done by other people. They will just, this is your, and then you take with this body. Whether it is stinking, whether it is bleeding, whether whatever it is, they just do postmortem. You ask them, immediate first question is, did you verify your meaning with reference to other three? You have relied on only one specifically mentioned. What about other three specific? Forget about others which are not named. I can follow that. What about three other names? I don't know. I don't know what India thinks about it. India was a party. I don't know what Pakistan thinks about it. I don't know what Malaysia thinks about it. Thailand thinks about it. They kept quiet. These are countries, they are not individuals. Can you presume that they don't read? Well, you may presume it. The people, those who represent them, they did not read it, they did not think about it. It may well be possible. But their answer, I am sure, is, where does the Vienna Convention say that you must exhaust all these four? You know, the problem is if they exhaust four, the other will say, why didn't you exhaust this one? They will say this. This is also a context. The ultimate thing is the realism, theory of realism, that you are reading jurisprudence. That immortal Oliver Wendell Holmes, prophecies of what the courts will do in fact and nothing more pretentious are what I mean by the law. Ultimately, you have to accept them to be correct. Why? The question is there is nobody else you can turn to. So this is very important. So after having seen this very closely, then you can see that it is enlightening. Otherwise, simply, reading these two cases and reading cases is not a bad thing. But the message that you draw, the learning that you draw, that is important. So use cases and literature as a tool, not an expert witness. And this is a case, this is no sister associate, this is a rule. We are not rules. I think to that extent, these statutes, they actually mislead people. I have no aversion that they use cases. I have no aversion that you read, you say. You must be frank to say what it is, and you must also be honest to say what it is not. Tell the student then what it is not, which they do not. And they also believe that it is also this. Now you see the law, Vienna Convention. Now you compare about those maxims and Vienna Convention. Where do you get to? What importance do you feel of these maxims? Useless. Just simply useless. Because they are simply illustration that in 20 cases this maxim was applied. This much of knowledge if you want to collect, I think in today's age of internet, and you have Wikipedia or whatever this, I don't remember how many, you see data. In that age, if a teacher is going to tell you that these are 20 cases on this, I think a good librarian can do that. A librarian knows more reference than a teacher, just as a chemist knows more number of medicine than a doctor. But a chemist is no doctor. Chemist can tell you names of 5 fever tablets, but only a doctor can tell you which one is to take, which you should take, and what is the meaning of this medicine and what is the meaning. This is the same. I am not averse to using examples and citing cases and references, but believe me, we must also tell the students the message that you get, the learning that you get. That is a very poor law that we apply in domestic courts. The realism is this, and the Vienna Convention is a reflection of this.
They agreed on 4 and they did not agree on others. But they agreed on including. Look at this. They agreed that male members should be invited, but they did not name who should be invited. The same question arises. Why did you specifically name them? Further question, what is the difference between named annexures, named context and unnamed context? The difference is basically of the degree. That if an interpreter ignores a written context, specifically mentioned context, misapplies it, abuses it, you can easily catch it. But applies it or misapplies an undetermined, very difficult. Very difficult. First, you can't challenge that why are you applying it. The interpreter will say, well, this is written here. I believe that this is also a treaty which is relevant. Which is the context. Good. But let me also tell you, in the final word, the specifically stated examples of context in the Vienna Convention are themselves very comprehensive. You again go home and you read the text. You see, I can understand preamble and annexure. They are infinite because you can find them in the treaty. They are stated and you can download the text. But treaty-related agreement and treaty-related agreements and treaty-connected instruments. No, related and connected. And deliberately they have used two different words. Related, agreement, connected, instrument. So many things. So many things are. So it is very comprehensive. It is very comprehensive. So be very sure about it. It's very comprehensive. It's very difficult to say that something is excluded. But it is also true that faced with a situation where meaning is not coming, which is considered to be reasonable and not absurd by an interpreter. An interpreter is not a prisoner of the tools of the Vienna Convention. Properly seized of a matter by an international tribunal, a tribunal is also allowed to go beyond the Vienna Convention, the specific words, including specifically named examples of context to resolve a dispute properly before. This is, if you debate now it becomes a matter of basically jurisprudential debate. Remember Roman law. And remember the context of Roman jurists who would write when the law as pleaded to them is not clear, they would not pronounce a word. But please also refer to Code Napoleon. You know what does it say? A judge who says, after hearing a matter that the law is not clear to him, shall be prosecuted. Because I have pleaded it to you, and you are a judge. If you do not know the law, you know what will happen? Whom will I turn to? You must devise the law. You must settle it on the basis of some reasons. Because you are more qualified. Even if not qualified, you have been given this responsibility and you have accepted it. So you say it on the first day. I don't know the law, resign it. I have seen, I will not name some of the cases I have filed and I have pleaded before courts, Indian courts. After hearing a matter 6 months, the judge says, I don't know how to decide. Then the matter is sent to another judge. The another judge, after hearing it, 6 months saying, I don't know. I asked. One of them was my student, so when I came to know later on, I declined to appear. I said, I will not argue. Not my student directly, my rabbi was recognized it, some affiliated college. Well, I said, I don't recognize your faith, otherwise I will not appear. Why? Because I know the reason. They know the law. I am 100% sure they know the law. The reasons are not their knowledge, the reasons are something else. They do not want to countenance a course of action which is perforce followed if they decide it. So this is not question of lack of knowledge of law. This is something more than that. So if it is still a case that if you apply on any equity, any reason, any common sense, because if you decline to exercise this, what will happen to the countries? Where do you do? I remember before the Supreme Court Justice Lakshmanan, some Justice Lakshmanan, Supreme Court judge, he was hearing a petition which was listed before him by a very famous politician of India, and some newspaper report published in the same day newspaper that he said if matter is going to some oblique threatening remark, oblique, not direct threat, oblique, which can be interpreted as if it is a threat. You know what happened? As soon as the matter came to him, he started crying, beating. He said his heartbeat and his whole BP got up and he threw the file and ran away. He left the chamber. This you are a Supreme Court judge. And you believe it? He simply did not proceed with the matter. What is this? And he himself interpreted that statement to be a threat to himself and his family. So therefore, there is a big discussion there, and the reason is sometimes the settlement of a dispute is not subject to known rules. The category, the task, the challenge of a dispute settlement is far more comprehensive and may call for reference to application of several things than may possibly be found in those, you see, textbooks, in those laws which have been devised for resolution of dispute, including the BRL. Any further question I would have loved to, you see, elaborate on further things, but I have another